Yeah.
My Lords, I'd indicated before the short adjournment that I might go to a further decision of the Aarhus Convention Compliance Committee. You may be pleased to know that, in fact, I think I don't need to go there. It's the UK decision. It's in tab 37 of your bundles. It says, as my Lord Mrs. Coulson would say, I think nothing that one couldn't discern from the language of the Convention in any event, namely that it has a broad interpretation, as I've been contending for, and relating to means affects the environment. So there we are.
But relating means?
That the decisive test is affects the environment. So affects rather than relating to.
That was tab 37.
Tab 37. It's the Austin complaint. It went to the Convention Compliance Committee, and of course a rather different approach was taken by them than by our own Court of Appeal. But of course the Court of Appeal is the Court of Appeal, and the committee is the committee.
Well, at least I got that right.
Article 32, Travaux Preparatoires. I don't propose to go back to those documents. If I could just go to my learned friend's skeleton argument, that's at tab 9 of the core bundle, page 53, paragraph 31.
Yeah.
And this is where my learned friend addresses the travaux, and towards the end of paragraph 31, in the penultimate sentence, it says, while some delegations contended that no provision in the form of what became Article 9.3 should be included in the Convention at all, others suggested that the Convention should include a right to challenge unlawful acts or omissions by private persons or public authorities which contravene specific provisions of national environmental law. Mm-hmm. This proposal was in due course adopted by the parties. So, of course, I say that that's an inaccurate summary. You'll recall that you were taken to parts of the notes of a working group discussion in which various views of different delegations were set out. One of them said that in relation to specific provisions of national environmental law. And of course, the text of the Convention that we end up with is provisions of national law relating to the environment. So we don't have the word specific, and we have the adjective environmental taken out of national environmental law, and instead we have the connector relating to inserted. So I say the last sentence of paragraph 31 is wrong, but you could tell that anyway by looking at the Convention. And that's all I need to say about the travaux. Mm-hmm. So that draws the Vienna Convention part of my submissions to an end. We've looked at the various buckets or silos of consideration that we have set out in the Vienna Convention, and I say every single one of them, objective and purpose of the Convention, context, wording of the provision, subsequent state practice, different authoritative texts, every single one of those boxes that one can tick goes in my favour. And that's in favour of a broad and facilitative approach to the meaning of provisions of national law relating to the environment. Those are my submissions on the Vienna Convention. I'll turn now to points which I say can be taken from the authorities. I said, I think, before the short adjournment that I have 6. I think, in fact, I have 9, but I hope to go through them quite quickly.
I'll change my heading.
I'm sorry about that.
That's all right. I like a good heading. So 2, 9 points from domestic authorities.
Not just domestic, because the first one is the Deutsche case.
Oh, okay. Yeah, right.
That's one of the ones that's been
9 points from authorities. So 1, Deutsche.
Deutsche. So we find that in tab 21 of the authorities bundle, page 437.
Yep.
And the summary, just for your Lordship's note, of this authority in my learned friend's skeleton argument, paragraph 10, subparagraph 5 of their skeleton, is that in this case the Grand Chamber held that whether a law falls within Article 9.3 turns on whether it has an environmental objective. And I say that's wrong. So if we go to paragraph 16 on page 463, sets out Article 5, sub 2 of the relevant regulation. My learned friend referred to it earlier. It's the defeat device prohibition.
Paragraph, sorry.
16.
Thank you.
On page 463. And it provides the use of defeat devices that reduce the effectiveness of emission control systems shall be prohibited. In paragraph 29, page 466, we see that the KBA, so the KBA is the relevant German regulator, granted authorization for the software at issue and taking the view that defeat devices still present in the vehicles were lawful. They've been changed slightly. And the KBA said it was fine. The applicant, we see in paragraphs 30 to 32, sought to appeal against that decision. Paragraph 50, which is on page 470, 30 to 32.
So paragraph?
Oh, sorry, paragraphs 30 to 32, which is on page 466 to 467. That sets out the appeal. And the first question referred, we see on page 470,
Yeah.
relates to the scope of the Aarhus Convention. Paragraph 50, we see the conclusion stated first. It must be found that an administrative decision, that's the decision of the KBA, granting or amending the relevant type approval in relation to Article 5.2 of the regulation falls within the material scope of Article 9.3 of Aarhus, since it constitutes an act of a public authority which is alleged to contravene the provisions of national law relating to the environment. Then in 51, we see that in various other cases, none of these cases relate, I should say, to Aarhus in 51. They all relate to contractual or tortious cases in which the objective pursued by the regulation was considered, and it had been held that the objective of that regulation was environmental protection in that different context. Then in 52, and this is where my learned friend started his reasoning, the Grand Chamber says, perhaps unsurprisingly, the finding that it has such an environmental objective and therefore forms part of the law relating to the environment is not, and then it addresses the issue in the case, is not undermined by the fact that a different legal basis was used to adopt it. So it was a harmonising legal basis, not the environmental legal basis in the treaties. So what the Grand Chamber is doing here is it's taking the prior finding of objective.
Sorry, when you say basis, you meant the source of the power to make
the regulation.
To make the regulation.
Absolutely.
It didn't have to be an environmental
It doesn't have to be an environmental source. It can be a harmonising source. That's point one. So that argument was a bad argument, and that was the issue.
A single market level playing field.
Absolutely.
Okay.
Exactly that. Exactly that. So that was the point in issue. The point in issue was not, do you need to have an environmental objective to be in 9.3? So when my learned friend says, in his written argument at least, that the Grand Chamber decided that issue, that the scope of 9.3 turns on objective, that's absolutely wrong. What the Grand Chamber is saying here is simply, because it had an objective, of course it's environmental law, and it doesn't matter that it was determined on a different legal basis. It didn't address the question, nor could it or should it. What if it didn't have that objective? What if it was in other ways related to the environment? Which is, of course, the issue which is before this court.
So it's not purporting to define the boundary of Article 9.3 by reference to environmental objective?
Absolutely not.
Environmental objective is sufficient but not necessary.
That's it, my lord.
Well, certainly sufficient, but they didn't actually deal with the question as to whether it was also necessary.
They didn't deal with that question.
They didn't have to.
But of course, we know from the, or I say that we know from the materials that we've looked at already together today, that one can't require an objective. It's just relating to. And when we looked at that part of the implementation guide, but also the Austria case, which said may affect or may impact on, my Lord Justice Coulson said, well, of course that's included in the words related to. So I say, if the Grand Chamber had said objective, that would be wrong. obviously isn't the case that you need to have an environmental objective, of course not. That would mean something different. Then, so that's point 1. Point 2, and this is a short point, provision does not mean written law. Now that was something that was put to Sir James this morning, and he readily accepted, I think by reference to Venn, but of course one also has the example of Austin, which concerns a private nuisance claim. So although the word provision to us might connote the idea of something being written down, that isn't the case. Provision also includes common law obligations and public law obligations. Point 3, which one can also take from the authorities.
I understand how Austin supports the first of those two propositions, common law obligations, but is it dealing with the public law aspect?
To the extent that the objection is it's not written down, yes, it would also deal with the public law aspect. What I'll come to in due course...
Well, I mean, it's saying that it doesn't have to be statute law. Even common law is written down.
That's true.
Somewhere.
It's written down somewhere. It can be recorded and it's in the cases, of course.
But it doesn't have to be statute law.
Absolutely, and public law principles also emanate from the decisions of the courts.
Yeah.
There's no distinction in principle between administrative law obligations and conventional common law obligations in that sense. One can come on to bindingness, and that's my next point.
Well, you see, the law of nuisance, and there were two additional tests imposed by the Court of Appeal to make it referable sufficiently to the environment, because not all nuisance claims will do that.
Yeah.
And if you just simply go to a textbook on public law, the principles aren't referable to the environment as such. They apply in all sorts of contexts.
Absolutely.
That's the point Sir James is making.
That is the point, and all I wanted to do was to make sure that we all agreed, and we do all agree, that the mere fact that they're public law obligations, so articulated by the courts,
Doesn't prevent them from being taken.
Doesn't prevent them.
But again, it may not be sufficient.
it may not be sufficient. That's what we'll come to.
We're looking for the excellent agreement.
We're looking for the extra bit. One of the reasons why I thought that was a point worth making is, of course, Sir James comes back repeatedly to the statute, and we'll come to that in due course. But there is a risk of treating the word provision as if it means statutory provision, and one sees that in his argument. Point 3, the word law is not limited to binding rules. So we know that because of Venn, and then of course the court considered the position for those planning policies, and set out in paragraph 16 of the judgment, it was an obligation on local authorities to have regard to national planning policies, just to have regard duty. For decision makers then also to have regard, and if the policies have been included in the development plan, for them to be followed unless material considerations indicate otherwise. So have regard duties, and follow unless there's a very good reason not to, conventional approach to policies. So again, we've addressed the word provision, but the word law doesn't mean binding. It doesn't mean that you've got no choice but to abide by it.
And your authority for that is Venn,
It's fair.
which is very much in the specific planning context.
So,
I mean, when you come to planning law for the first time, you are staggered to see the importance that everybody gives to the MPPF. And you think, hang on a minute, this isn't statute or doesn't have any force of that kind. But once you become familiar with planning concepts, you see that that is the way in which planning law and the protection to the environment that's the practical way in which it happens.
your Lordship will know that far better than I do. In Venn, it's described as a have regard duty, and it may well be that one has regard and almost invariably follows, but it's a have regard duty. And your lordships will recall section 28, in my case, is a have regard duty. So to the extent that my learned friend says, oh gosh, they don't really count, they do count.
Well, section 28 will come to it. Does that have regard to relevant international arrangements?
Yes.
I mean, it may be helpful to think about how you define relevance in that when you get to it.
Of course, my lord. Well, I can approach that now because we say that the UNFCCC was a relevant arrangement to the extent that it was an error of law not to recognise it as such. So by that I mean...
But isn't there an interpretational question as to what section 28 means by relevant?
There is, my lord, but we have to argue the case today on the premise that I'm right. So that was one of my further...
Not speaking for myself, if you're on a particular point, if you happen to be clearly wrong. I mean, there's a question of law, isn't it, as to what is relevant. It wouldn't relevant, and there is a broader question of interpretation which we're being asked to resolve, not just for the purpose of this case, but others. Wouldn't relevant to section 28 have regard to the purposes of the statute, or at least section 28?
Sorry, the word relevant has
yes.
regard.
I mean, you see this actually, I'm sorry to go back to planning law, but there is embedded in the statute the phrase material considerations. It means relevant considerations. What defines relevance is the purpose of the Act, which is to control land use, anything which is affected by that. It's a very, very broad purpose, but you use the object of the Act to define what things are relevant planning considerations and what are not. Might that not be a way of approaching relevant in section 28?
That's right, my lord. And when we were arguing this at the permission stage, and of course permission was granted, when we were arguing this at the permission stage, I approach this on the basis that it's very similar to the viewings assessment that I'll come to in due course. So, of course, category 1, viewings, mandatory one gets from the statute. Is that what you're saying?
Expressly or implied.
Exactly so. And then category 3, with the irrationality overlay on the facts, it would be irrational. It's so material, it would be irrational not to take it into account. And I won on that argument.
And there is a little bit of Lord Cook in the name of the case, Creed NZ, which is it's irrational in terms of it would ignore the object of the legislation. It wouldn't be in accordance with the object of the legislation, and therefore irrational.
That's right. So
in a sense, both those tests are points of interpretation of the statute.
I think that's right. I think that the reason why we have category 1 and category 3 Wednesbury is because there remains a difference between the two. Otherwise, category 1 viewings and category 3 Wednesbury would just collapse into one another.
Yeah, I can see that.
And to my mind, the difference between the two is how closely it's related to the statute. But of course, the statute comes into both of those. Of course, I see that, and one can never entirely put the statute from one's mind. But my point is this for section 28, that it is so obviously material when the UK has signed up to the UNFCCC and has promised, when it takes a relevant decision, that it will take climate change considerations into account. And then it takes exactly that sort of decision domestically, and it asks itself, I wonder which international arrangements may bear on this. That is one of those arrangements which it would be irrational not to take into account. That was my submission at the permission stage. I say it's right.
Okay, anyway, you were on your third point, which is the taking into account point from then.
The taking into account point from then, absolutely. That it doesn't need to be a mandatory rule of law, and taking into account where, of course, one can, as my learned friend says in his skeleton argument, ultimately take into account and attach no weight to something. That still is a provision of national law. The fourth point is that the authorities warn against drawing a line in the middle of applicable legal framework. So we get that again from then, but also from the Friends of the Earth Mozambique case.
So warn against drawing a line in...
A line in the middle of an applicable legal framework. So imagine one has a statutory provision which says nothing about the environment, but just says have regard to policies which are made by person X. And those policies are all about the environment. It's wrong to draw a line between the two of them. That's what's said in Venn, that you don't distinguish between the two, and they form part of a whole. And that is also what Mrs. Justice Thornton said in the Friends of the Earth case, when she said, you have the power to make the funding decision. The statute in that case also established an advisory body, which had been specially tasked with giving advice on climate change impacts and compliance with Paris. And also the defendants had, at least on the understanding at the time, had promulgated a policy saying they would consider compliance with Paris. And Mrs. Justice Thornton said, it makes no sense to distinguish between those different parts of the statutory framework. So that's point 4.
But if you're not obliged to adopt that policy, obviously if you do adopt it, then duties, certain public law duties follow from it. But if you're not obliged to adopt it, how do you justify saying that it is automatically to be regarded as one indivisible whole with the provisions which do impose obligations on you?
Because if one's considering the legal framework that applies to any decision, the rules which the decision maker needs to adhere to, the considerations they need to take into account, one identifies the statute, one identifies requirements in the statute, but one also says, you have published this policy as a matter of domestic English law, it is binding on you in this particular way. You must do what it says unless there's a good reason not to do it, for example. So it forms part of the legal regime domestically. And it's on that basis. It was their choice to adopt the policy or not, but having adopted it, it becomes part of the rules which govern their decision making.
When you adopt a policy, there's no legal principle which says you have to apply it. You can decide that there are reasons why you don't want to. But the existence of the reasons is for the decision maker, not for the court.
The existence of the reasons is, but one can't publish a policy inconsistent with good administration, just immediately throw it in the bin. It becomes part of the...
That wouldn't be a good idea.
No, that wouldn't be a good idea. That wouldn't be a good idea.
But it's elevating the status of a policy to a rule. Seemed to be the way you were putting it. Maybe I misheard.
I keep on using the language of legal framework, and I hope that that may be helpful. So when I say rule, what I mean is I'll say rule again, the framework, the considerations, or the parameters, the legal parameters of the decision which the decision maker can take, and the questions which the decision maker has to ask his or herself in order to step outside.
And policies come in all shapes and sizes. You have policies which statute says you will take into account. But in a looser sense, policy is just the production of guidance to help decision makers reach consistent decisions.
Of course.
It's no more than a tool for decision making.
It's in my submission. It's slightly more than a tool, because it's a controlling factor on those decisions, and the decision maker has to ask themselves if they're going to do something inconsistent with that guidance.
You're not relying on policy here.
There is a policy, so we're relying on Section 28. There's also a policy.
Yes. When we get to your alternative basis,
there are various alternative bases, but it's principally Section 28, as you know.
Yes, but the alternative Section 28, the choice approach, could you at some stage identify, and I apologise for missing it, the policy you rely on?
Yes, of course. I'll take you to it when I get there in my submission. But I know that we're going out of order a little bit.
That's my fault.
No, not at all. But I wonder if something that's interesting to think about as well when we're having these discussions is the point that your Lordship made this morning about 9.3 compared to 9.4, and 9.3 having the objective of providing a remedy. And if we ask ourselves the question, would it matter to the Convention if an unlawfulness occurred in relation to, for example, the breach of that policy, would it matter? And I say, well, yes, it would matter. It would matter. The rules or the requirements or the considerations to which the decision maker takes into account when they make their decision, if they are, for example, irrational, they do the equivalent of putting the decimal point in the wrong place, and it's related to the environment, and the consequence is something absolutely catastrophic for the environment, it is very strange if that falls outside 9.3. That's my submission. Point 5, this takes us on to analytically slightly more difficult territory in a way, I think, because this is the distinction between the decision and the claim, which is a point that was raised with my learned friend this morning. So we see just in the language of Article 9.3, there's a distinction between decision and claim. We can see that on the face of it, that we have the actual omission, and then we have the alleged contravention of national law relating to the environment. And we have Mr. Justice Eyre in the Lewis case, in quite an easy case in a sense, making the point that he makes. So in that case, the decision was in relation to a cancer care unit, and the alleged breach was of a totally different requirement stemming from a Biodiversity Act. And it was said repeatedly to him in submission, well, what matters is the nature of the viaries giving rise to the building of the cancer care centre. So ignore biodiversity. And unsurprisingly, he said, well, no, that can't be right. I disagree with that. But in many cases, the two will be closer together. And I agree with Sir James in that regard. Though I would say, I'm going to address two cases where they're close together. But in general, I do say it's helpful to distinguish as much as one can between the decision, the powers that gave rise to the decision, and the nature of the alleged wrongdoing. And that is a helpful discipline when thinking about these cases.
And the nature of the wrongdoing?
The nature of the wrongdoing, the thing that's said to have been contravened.
Yeah.
That's plain on the structure of Article 9.3, and it is a helpful discipline, even though it's not always easy to apply. So the first point I'd like to address is ultra vires, which is the way it applies in this case, at least if one ignores Section 28, and one imagines we're arguing this on policy or on irrationality in relation to optional considerations. And so one of the ways in which that sort of public law error is put on occasion is as an ultra vires error. So you have the Section 9 vires or Section 11 vires here, and it said you did something irrational when you were exercising that vires. But in my submission, that's an example of where the distinction between claim and decision becomes particularly difficult. And it's for this reason. There is, I think, classically understood to be varying different permutations or types of ultra vires. Mr. Justice Fordham sets them out in his book, but I think we all understand that to be the case anyway. So one has a narrow vires challenge in which you literally look at the empowering provision and you say, you went outside that. So it said you can grant benefit X to people who are 19, and you actually granted it to people who are 20. You went outside the express terms of the vires. Mr. Justice Fordham says there's then an interstitial category of vires where you also look at implicit limits to the vires. But again, the argument is all about the statutory language and how it's to be construed. And then there's a broader kind of ultra vires challenge, which is essentially any public law error will go to vires. So the basis, the analytical basis for that argument is, of course, no decision maker is ever given vires to act irrationally, or no decision maker is given vires to act in breach of their duty of reasonable inquiry. But putting that as a vires point obscures the fact that the legal error is in fact unconnected to the vires. It's not to do with the four corners of the vires. It's to do with general duties of good administrative decision making. So that's something that arises in this case, because of course it's said repeatedly in relation to grounds 1 and 2, well, it's an ultra vires challenge. That's why we spend 6 pages of our skeleton argument talking about the nature of the Taxation Act. But that's to mischaracterise, albeit subtly perhaps mischaracterise, the nature of the wrongdoing. It's not a vires complaint. That's point one. Point two, again, one of the tangly areas between claim and decision, impact on the environment. So we saw, when we were looking at the Austria case together, that relating to includes any law which may impact on the environment. So the focus here is still on the law which is said to have been breached, is that that law may impact on the environment. But it probably is right to say that in many cases there'll be a very close connection between the impact of that law or adherence to that law and the impact on the environment of the decision under challenge. And it's for that reason, I think, that one often sees it conflated. And it may be that, in fact, the correct way of assessing environmental impact of the law is the delta, if I can use that language, of impact on the environment of the decision. So if one were to ask oneself, would the impact on the environment of the decision have been lessened were the law to have been complied with, that may give us a way of squaring the circle. But I do see, and I just wanted to acknowledge and discuss with you, this difficulty about impact. My learned friend referred to WWF's case about impact being the test. That isn't my case, it's not my primary case. I don't say it's wrong, but I don't advance it. But what I do say is that plainly, if one were to be thinking about impact on the environment of the FTA, and for the purpose of my judicial review, its implementation, it has a very significant impact on the environment. My claim is that there is an enormous greenhouse gas impact. And my claim, and now we come back round the circle, my claim is that if the defendants, the appellants, had complied with their legal obligations, then there's at least a good chance they would have taken a different decision and the impact would have been lessened. So we use impact of the agreement as a way of testing impact of adherence to the law. Now, impact isn't part of my case, so we don't need to get into those murky waters. But I just wanted to raise...
Well, we do.
Those...
We do, because WWF are saying
They are.
that that's the test. I completely understand your submission. And anyway, you know, we're back to relating to. I mean, it's a fairly straightforward argument that if something has a significantly negative impact on the environment, it's likely to relate to the environment. But their submission is much wider than that.
It is.
And we will have to address it because that's their submission. So I understand your submission, and I understand your submission that your case, whilst your case is that this would have a significant impact on the environment, that's not how you put it as a matter of law.
Exactly so.
Okay.
Can I just see where we're going? The regulations are about tariffs.
Yeah.
That's their purpose. Their purpose is to set tariffs, and to set tariffs pursuant to an FTA which has already been agreed, so which is not challenged. Change the facts a little bit. And imagine we were having a tariff spat with the United States. And in order to submit to the will of the United States, the tariff on the importation of motor cars from the United States to this country were to be reduced. Reduced, not abolished, but reduced. And let us say that someone comes up with the idea and the complaint that American cars are more gas guzzly and therefore pollute more than English cars or European cars. And let's say that an interested person like your client decided that they wanted to challenge the reduction of the tariffs on that basis. Do you say that that would be an Aarhus claim?
So I say that under Section 28, they would have been obliged to take account of Article 4.1 of the UNFCCC, so they needed to take that into account, and then I'd consider the quality of the decision-making and challenge that. And I know that may appear to be a cute answer, but that is what I'd say. I'd then also rely on the policy that applied. Then I'd work through mandatory considerations, then optional considerations, and then and only then would I be coming to pure impact.
So
if one's in the world of pure... Sorry to...
So it's central to that submission that we need, or would need in the case of the gas guzzlers, need to find that Article 4.1 was part of the national law of this country relating to the environment.
Via Section 28. That Section 28 is part of the law.
Okay.
And via Section 28, it has the teeth it has via Section 28, and those teeth are domestic. So we had, this is very unhelpful for me to say, but we had this argument in part at first instance. My position is national law means anything that sounds at the national level. So I wouldn't come to the court and say there are international obligations which I say are rendered justiciable in some sense via Aarhus. That's wrong. But I say to the extent that I can run any argument justiciably with teeth in relation to an international obligation here, so it sounds as part of the national law here, then that forms part relevantly of national law for Aarhus purposes. That hasn't been developed.
4.1 is an unincorporated, part of an unincorporated treaty.
It is, exactly.
It's not part of our domestic law.
No, which is why Section 20...
It made part of our domestic law, you say, under Section 28.
It's Section 28 that pulls it in.
Or otherwise, and obviously, well, yeah.
Well, no, we put in a respondent's notice in relation to it otherwise being part of the law. We don't say it's otherwise part of the law. It's Section 28.
It's Section 28.
And that pulls it in. It pulls it in enough for it to be relevantly national to the extent that it is.
I think the reason where I'm getting confused, or one of the reasons why I'm getting confused, is that suggests that what we're really interpreting is not 9.3, but Section 28.
Well, your lordship is asking whether Section 28 falls within 9.3. So there are two interpretive exercises, aren't there? There's 9.3, and once you've decided what the scope of that is, we look at the various different national laws which are alleged to have been contravened, and for each of them we pick them up and say, are you in or are you out? Now, I think that the question that your lordship was putting to me and trying to test was whether I would say, if it was impact alone, could a member of the public, including an NGO, go to court and say that forms part of the law relating to the environment? And I would gratefully adopt what my Lord Justice Coulson said in relation to significance of impact. I think that's probably the best way of testing it. So if something were to go wrong, and of course something needs to have gone wrong in the first place, the slight difficulty with the example we're discussing is we've not really identified what the legal error was. But if there were to be a legal error and it were to have a significant impact on the environment, then quite possibly it does relate to the law relating to the environment. My case is not like that, because in each instance, environment is in big lit up letters on top of what's going on, right?
But
so
it would be, wouldn't it?
It would be. It would be. But we've got the UNFCCC. We've got the policy that says we'll take the climate change impacts into account before implementation. I'll take you there. We've got our ground 1C, which is a ministerial briefing point, necessarily then a mandatory viewings point. And we've got optional viewings. But on each occasion, there's a heading saying climate change impact. So we're just not in a world where we have to think about impact that's not been recognised by the decision maker, if I put it that way. Is that of any assistance at all? I don't know.
Maybe.
I think that's a no.
I think I understand what you're saying.
Okay.
Anyway, so that's your fifth point.
That's the fifth point, yeah. So the difficulty of claim and decision, thinking particularly about ultra-vires and impact. But I do cleave to and I adhere to that distinction between decision and claim, recognising that it can be difficult on occasion. Point 6, a relatively quick point. This is the point that I was discussing earlier with my Lord Justice Holgate. Contravention at this stage means the alleged contravention. So I do say, and I understand this to be common ground, not least because I think my friend said it on his feet this morning, that it's assumed that I'm right.
Yes.
So one doesn't take pot shots at the alleged contravention at this stage. Still less when
Well,
having
the poor
grounds
old
conviction.
judge, the poor old judge who's got to have regard to the Vienna Convention and the Travaux and the negotiations and then the 9 points from the domestic authorities, and we've only got to the 6th. It would be pushing it a bit if he or she also had to decide whether or not you were right, and might make the rest of the litigation somewhat redundant. We have to bear in mind that this is a summary, intended to be a summary, quick in and out process, not layered like an onion, but something that a judge can immediately grasp, see the rules, see where the lines are, and decide it.
I'm very grateful for that. And your Lordship knows my submission is that the whole onion is in. So
of course, it has to be the alleged contravention. And of course, that does mean, and it's arisen in a couple of the cases, that if you get to the end and it turns out that the claim's hopeless, but it still had the Aarhus cost protection, which is an advantage not provided in other parts of the civil justice system. In fact, to use a buzz phrase this week, it might be said to arise or give rise to two-tiered justice. If you're an environmental claimant, you get this protection. If you lose your hand in a factory accident, you don't.
it's true, my Lord.
I understand the riposte is we should have a better funded civil justice system. I agree with that. But in the present circumstances, it is actually a two-tier system. It's just a two-tier system that, in general terms, subject to the edges, which is what this case is about, everybody thinks it's a good idea that environmental claimants have cost protection, hence Aarhus. But it's quite an interesting riposte to two-tier justice. It depends what the two tiers are. Yeah, anyway, contravention is the alleged contravention. So it assumes you're right.
Yeah, it assumes I'm right.
Yeah.
Point 7, if one of the grounds of challenge in a judicial review is an Aarhus Convention claim, then cost protection applies to the entirety of the claim. So that's the approach taken by Mr. Justice Eyre in the Lewis case. I understand it to be common ground. Anything else, as he said, would be not only contrary to the language of the rules, but unworkable and would have exactly that kind of satellite litigation.
Well, which rules?
The CPR.
Yeah. Can you just give me a reference? Okay, please.
Look behind me, and then I will give you a
Thank
reference
you.
from Wales Custody. 7, I can deal with this pretty quickly. It's just Client Earth.
I thought that was 7.
Oh, sorry, 8. Not renumbered very well.
8, yeah.
8, Client Earth. And in particular, it was put to me this morning whether I say Client Earth was wrong or not. And I hope, yet again, I may appear slightly coy in my answer. I say it may be wrong, but it doesn't matter to me, which is probably a very unhelpful answer. The reason I say it doesn't matter to me is it's an entirely different case. As my Lord Justice Holgate was saying, the concern in the statutory regime in the prospectus, at the heart of that case, is essentially the identification of material risks for investors. So it's all about investors.
Well, if you're going to say it's arguably right, I think you'd like to know, because it may impact on your other arguments.
It may impact on my other arguments. The reason why it may arguably be right...
Sorry, arguably wrong. I meant to say.
It may arguably be wrong because in the judgment there's a reference to an internal policy document, a note. It's not really explained what it does. It's a very short judgment, as my Lord Justice Coulson said. I don't really understand all aspects of the regime from it. An internal note saying that typically one would expect environmental risks to be included in the risks that are disclosed. And it may be that that would be sufficient to say that the FCA knew what they had to look for, what they were controlling for in particular, was adequacy of disclosure of those risks. So that would be the argument that it was wrong. There's also perhaps an argument that it was wrong in terms of the reasoning, because the learned judge, Mrs. Justice Lang, focused on a couple of decisions from the information context you don't have before your lordships about purposive approach, thinking that purposive was limiting, but in fact those cases show it's really facilitative. And she also went back to Austin, but we know that Austin now is a little bit of a funny judgment because of the approach of the compliance committee subsequently. In any event, it's probably just about private nuisance. So there are various features of that case, which in my submission mean that it should at least be treated with a degree of caution or just applied to its particular facts.
But even if the reasoning is open to criticism, is the result open to criticism?
Well, sorry. The result is open to criticism if it were to be right to say that what the FCA is doing is considering a part of the national legal regime relating to the environment, and you'll say, well, that's no more than the legal test. But my understanding is that it's seen that this prospectus obligation and ESG obligations do form part of environmental protection. Whether that's right or not, I don't know. I haven't considered it in enough detail, but that would be the basis for saying that it was wrong.
Well, it would have to be, but I just struggle to see that.
Well, I struggle to see it, but one goes to conferences, or I have been to one conference, at which it was said that this is an important part of shoring up environmental protection. I don't know if that's right or wrong, but that's the way one would run the argument. It doesn't matter to me enormously. It's one judgment, and of course, as my learned friend very fairly acknowledged, it's a judgment of the same judge who gave us the judgment in this case that she delivered 4 or 5 months earlier. So
yeah, I think in her judgment in this case, she explains why she thinks this is different.
She does, and I say she's right to do so.
Yeah.
So that's Client Earth, and then the final point is exactly the point your Lordship just made to me, that this all has to be easy. It has to be as easy as possible. So what I have is a world in which I say the whole onion is in. Now I'm going to address you on the basis that different layers of the onion are in or out. I say the whole onion is in. So by that I mean right the way up to Fewing's Category 3 considerations that are not so material it would be irrational to fail to take them into account. Truly optional considerations. I say that makes the test really easy for the judge to apply. They look at the formulation of the ground of challenge and they see immediately whether it's in or out. And I say that any other approach, in particular the approach contended for by my learned friend, is fraught with difficulty and with no discourtesy at all to Sir James. It was notable that he did not want to give my Lord Justice Holgate, a straight answer on the Transport Action Network case. You put to him the very straightforward point, my Lord, well, what if you've got a statutory scheme related to something else, funding, and you've got a provision in it which relates to the environment? Now, for my part, that's plainly a provision of national law relating to the environment, so it's quite strange that any other answer could be given than yes. But my learned friend did not want to give you a straight answer. And your Lordship then put to my learned friend, well, what about general obligations? They don't refer to the environment, but they say take relevant considerations into account. And my learned friend said, I don't want to be drawn into the difference between specific drafting and general drafting by Parliamentary Counsel. That was a very good point in my submission, because of course one has acts, like the Act in this case, which cover a wide range of activity, of policy area, and it is good parliamentary drafting, a good parliamentary drafting approach to have a generalised provision like Section 28. You don't say to the draftsman, please will you list for me 28 different types of treaty that could be taken into account to make sure I've got the word environmental in there. But again, my learned friend, and again with no discourtesy, but he said he couldn't tell you whether it mattered, whether it was general or specific. This is no kind of test at all. How can it be applied by a judge? I don't understand it. I don't know what I'm even aiming at. So I say, taking that, the final point, to be drawn from the authorities, or at least from the indications of this court, and it's entirely common sense, into account, it has to be the whole onion. I'll move now to the grounds in this claim.
Well, can I ask what's outside the onion?
Outside the onion.
What is by the onion? You mean all potential public law errors?
So I mean,
starting with failing to follow a statute direction to take something into account, down to viewings category 3.
Yeah.
I understand that, but we've still got to put that into a legal framework. How are you drawing the line?
So in terms of the nature of the legal obligation, it goes right the way through to all kinds of binding legal obligation. What's funny about this case, my lords, it's being argued as if it's all about relating to the environment, but the considerations obviously relate to the environment. So the whole thing is being put a bit wrongly, perhaps.
Sorry, maybe it's my fault. You're not going so far as WWF.
No.
So how far are you going?
I'm going so far as to say if the statutory obligation, or the policy, or the mandatory considerations, or the
sorry,
optional...
this is important. Can
Yeah,
you
of course.
slow down?
Of
If
course.
the statutory obligation...
Statutory obligation,
Yeah.
or the policy, or I'm going to say mandatory considerations, you know, I mean viewings 1 and viewings 3, rationality.
Okay, look, that's the...
Or the optional
I
considerations.
don't do shorthand. Viewings 1 and 3, yes.
Yeah, or the optional considerations. And by that I mean viewings 3, but one could rationally leave it out of account. I say all of those bases for considering the environment, all of them give us a sufficient basis to be a provision of national law relating to the environment. Now, what
That
I said,
even includes viewings optional 3.
it does.
Where you can't be criticised if you don't take it.
That's exactly right, my lord. So in that case, and of course this isn't my case, right? But in that case, what's happening?
Pure discretion, that last one.
It's pure discretion whether you do it or not. But having done it, having taken it into account, imagine you've got a decision you're making as the public law decision maker, and the consideration you take into account is acutely environmental, and you get it totally wrong. You think it's 1%, and in fact it's
Well, the way you embark
100,000.
upon it is irrational.
Exactly.
Yes.
You make a terrible, terrible hash of it. And because you did take it into account, you took a decision which was infected by that terrible error. The question for the court is, under Article 9.3 of Aarhus, should there be any way of a member of the public coming to the court and challenging it? And I say yes, even though, of course, the decision maker didn't need to take it into account, but that doesn't matter. What matters is they did and they got it terribly wrong.
But your drafting ended up with for considering effect. You mean for considering environmental effect or effect on the environment?
Yeah.
Yeah.
Absolutely.
How is this actually different from WWF?
So, for WWF, this is what I was trying to get at before, though I think I articulated it very poorly.
It's not easy.
It's not easy, but there's a line of argument that we've spent a lot of time discussing, we've just been discussing, about the nature of the legal obligation and how it arises and what one has to do in order to comply with public law principle. But then there's a different layer of analysis about connection with the environment. Now, in this case, it's not really a connection with the environment case because it's all about climate change and greenhouse gases and beef, beef, beef. We know we've got the connection. The WWF point comes in, as I understand it, where one doesn't have that kind of obvious environmental connection. But what one's looking for instead is the more peripheral impact on the environment. So Sir James would say something like, well, child benefit cap is going to change how many children families might have, and that might change climate change. So was the child benefit cap JR an Aarhus claim? That kind of argument. That's where impact comes in. But our case, although we've spoken so much about related to, it is, to take the words of Mrs. Justice Thornton in Friends of the Earth, it's quintessentially an environmental claim. We're obviously all talking about the environment. the basis on which it's said against me that it's not an environmental claim is by ignoring, in reverse order, optional considerations, mandatory considerations policy, section 28, trying to get us back into the Taxation Act, which is the vires for the decision, and say the Taxation Act, read as a whole, is a type of generalised taxation and so can't be relevantly environmental.
So, one way of summarising your submission perhaps is to say it covers all types of public law error, so long as the statutory framework, there's got to be a statutory framework in play, is connected with an environmental effect.
I don't think the statutory framework needs to be. One wouldn't have a policy or take the considerations into account if the environment wasn't somehow connected with the vires. But I would move away from always going back to the statutory framework. So one
Could be a public law power exercised under the common law.
It could be prerogative power. So if I start with ground 3, and of course if I'm right on ground 3, then the cost protection applies to the entirety of the claim. I've passed a note actually about the definition of claim. I might look at this when I'm sitting down and Sir James is replying, then I can stand up and give you the single reference once I've found it properly in the whiteboard.
Okay, so you say we're going to ground 3.
Ground 3.
Okay, so where's the best place just to anchor this?
It's pleaded at paragraphs 89 to 95 of our claim form, which is in core bundle, tab 12, page 138 to 140.
Yeah.
And we've set out earlier section 28. And if we haven't, I should take you to it in the authorities. Page 40 of the authorities bundle, that's the section 28 obligation. If your lordship just read that to yourselves.
Sorry, I missed that.
So section 28, page 40.
Yeah, got that.
If your lordships just read that requirement.
Yeah.
And then for the UNFCCC, we have Article 4 on page 490 of the authorities bundle. You'll see there at the top, all parties taking into account their common but differentiated responsibilities and their specific national, regional development priorities, objectives and circumstances shall, and then down at F, take climate change considerations into account to the extent feasible in their relevant social, economic and environmental policies and actions. And so we rely on section 28 to say that the defendant should have had regard to their obligation under Article 4.1f. when deciding to implement the FTA to have regard to climate change considerations. And we say it's so obviously material that it was an error of law to fail to do so. So I say that's plainly section 28, read together with Article 4, 1F. That is plainly a provision of national law relating to the environment. Sir James, when objecting to that characterisation, I think first of all relied on the have regard nature of the duty. Also he referred to the judgment of Mrs. Justice Cockrell in the Western Sahara case, which we both appeared in. But that really goes beyond what I say is permissible at this stage. So it doesn't take my argument on the basis it's right, and I think instead, seeks to say that
I'm beginning to get troubled about this. You're saying that we have to proceed on the basis that even though this is an appeal against the decision on Aarhus costs, we have to take the underlying allegations as correct.
I am saying that.
I know.
And I'm saying that's what the judge should do at first instance when they...
Well, again, I'm wondering about that because my Lord's raised this question. Aarhus decisions are taken at an early stage. Aarhus costs arise if a judge refuses permission on the basis that the claim is unarguable.
So
how do you square that circle?
If I'm putting it wrongly then, I shouldn't say you assume I'm right. I should say you take my claim and you consider the characterisation of that claim, wrong or right.
Well, I'm not sure I
think that must be right.
I can get a cigarette paper between that and the previous submission.
But, my Lord, I wonder if it must be right, though, because as you've just said, one can have permission refused, or permission is refused, and yet Aarhus cost protection is granted.
Would you necessarily give Aarhus protection if you had two grounds, and one was on the face of it an Aarhus ground, but you decided it was unarguable, so you didn't give permission for ground one. You gave permission for ground two, so the proceedings could go ahead simply on ground two. You wouldn't then call that an Aarhus claim?
That's a nice point, my Lord. I wonder if in that kind of case one would say the Aarhus regime addresses the costs up to the moment at which permission was refused.
Well, I wouldn't be inclined to say that. I mean, it seems to me, it goes back to something that was said this morning, that when Sir James was on his feet, that the party's protection, one way or the other, is that if a claim is unarguable, it goes. It's not brought, and you've wasted your money on trying to bring a useless...
Under the CPR, if it's not brought and it's not an Aarhus Convention claim, there's no orders to costs still there. I think I'm right in saying that. So there is a bespoke regime for those various permutations.
Well, there are. Well, you often ask for permission. You often ask for your costs of the acknowledgement of service.
Exactly.
So,
which can be above £5,000.
Yes, and if it's been argued that it's an Aarhus Convention claim, the CPR says that there'll be no order for cost of the proceedings.
If it's an unarguable claim, which if arguable could be an Aarhus claim, surely the answer is it has not been brought.
That may be what my Lord, I don't.
If the defendant has wasted money on your wasteful claim, nothing personal, but your wasteful claim, then why should you get protection for bringing a wasteful claim?
Well, when one thinks about whether claims are good claims or arguable claims, whether permission will or will not be granted, obviously one thing one takes into account is chilling effect at an earlier stage. And I'm not for a moment saying that claims which are obviously bad on their face should be brought. Of course, they shouldn't be. I think it would be very concerning from the perspective of NGOs if one were to think that when permission is refused...
Yes, but this is not
just very low bar.
Of course, it's both sides.
This is not just about NGOs. You could have a claim certified as totally without merit.
It's both sides. Should we just look at the CPR, because I worry that I'm making submissions which may be wrong. We have that, I think, at the beginning of the bundle. Yeah, tab 5. I don't know if there's anything that deals expressly with the interaction with permission. What we've got at the last page of that tab, page 55, is 46.28 sub 3 sub A. So if the court were to hold that the claim is not an Aarhus Convention claim, it would make no order for costs in relation to those proceedings. So if my Lord or
Except
Justice...
for good reason.
Forgive me, where are you?
Page 55. So
Except
if
for
the
good
court
reason,
holds that the
of course.
claim is not an Aarhus Convention claim, it shall, except for good reason, make no order for costs in relation to those proceedings. I suppose on the facts of any particular case, if it was, for example, certified as totally without merit, that might be a good reason for awarding costs against the claimant.
That's a very good point.
But that would then be on the facts of the particular case.
It would be on the facts of that case. And in other cases, I would read that rule as meaning if permission were refused, and if separately or for that reason, as you indicate, my Lord, the consequence is it's not an Aarhus Convention claim, there's no orders for costs, unless there's good reason to do something different.
I think we'd find a way to get there in the end.
We did. Sorry, I was rather slow in getting there.
And can I do, this is a purely procedural question to which I'm afraid I don't know the answer. As a matter of practice, is the Aarhus Convention dispute, assuming that there is one, decided at the same time as permission?
Yes.
It's normally, I asked that
Yes.
question this morning, and it's normally decided as soon as possible on the papers. That's often with the permission decision.
Yes,
But it can
so
proceed
on the papers, and then if permission is refused and or if the Aarhus Convention claim is rejected, then there can be a renewed application, and that will be an oral hearing.
Absolutely.
Yeah.
It's not often actually you get a dispute about whether a claim is an Aarhus claim.
That's probably why this appeal's been brought.
And the last thing we want is to encourage such disputes. That's my overwhelming concern.
Yes. I've picked that up even with my cloth ears.
Well, only because litigation about costs, although I find interesting, is not what I would be encouraging parties to be spending their money on.
No. Well, it won't surprise your Lordship to know that my client entirely agrees. We issued the JR over 2 years ago, so
Yeah.
it would be nice to move towards a substantive hearing at some
Well, I
point.
understand that. All right. So
ground three.
So you say ground three. So you rely on Section 28. You rely on Article 41F
Yeah.
of UNFCCC. So you say that that's the national law relating to the environment, which you say was contravened because they didn't have regard to the environmental, or to the the environmental. Well, you don't say impact, but
Yeah.
to the it relates to the environment.
So they misdirected themselves by saying we don't need to look at the UNFCCC. And then when considering environmental impact, they obviously made the host of errors that we've identified.
And under
in
ground
round
three,
one and round
the
two.
particular point I saw pleaded was that on the government side it said that the emissions are treated as occurring in Australia
Yeah.
rather than within this jurisdiction.
Yeah, absolutely. It's a really
And
interesting point.
that's the point which could be said to be specific to ground three.
Yeah.
Because if you're right about Section 28 and Article 4.1, you say that is failing to comply with Article 4.1.
I do, absolutely, that they've misdirected.
Whereas
Beyond tenable
the other
standards.
arguments, under mainly speaking, apart from predetermination, under grounds 1 and 2, are errors, you say, which were committed whilst embarked upon taking into account GHG, but
That's
they went irrationally about it.
That's entirely
Have I,
right.
in a
You've got it
nutshell?
entirely right. You have.
Okay.
And it's a very interesting argument in relation to Article 4.1f, because essentially what the defendants have done is they've taken other aspects of the international arrangements in relation to climate change, some of which do confine you to looking only at what's produced in the UK, in particular where there's a kind of accounting aspect to it, and one can't have double counting. And they say the same approach should apply to Article 4.1f. And I say that's totally wrong. 4.1f is a general obligation to take account of climate change considerations, and there's no reason at all to give it the interpretation that's been given to it by the applicant.
Well, GHG is only relevant because of the contribution it makes to a global effect.
Absolutely.
So if you enter into an arrangement which has an effect in a different country, it doesn't necessarily become irrelevant on that account.
No. And if we offshored all of our carbon to another poorer country and then said, well, it's no longer our problem, we don't need to think about it anymore, then that would be in breach of Article 4.1f. So there we are. That's the argument that we had at the Commission stage and the argument we'll be having at the substantive hearing if we get there. I think my learned friend also relies, or maybe principally relies, on the general nature of Section 28 and the fact that it doesn't expressly say including environmental obligations. I've addressed that already, at least in passing in my submissions. It would be arbitrary and wrong to distinguish between occasions on which the statutory draftsman has used the language environmental and occasions on which, in fact, the statute requires you to take those environmental considerations into account.
So he's entitled to raise that argument despite the fact you've got permission.
That's not permission. That's not a permission argument.
No, but you keep telling us that it's been decided your grounds are arguable. The point you've just summarised as having been made by Sir James is actually a point which goes to the arguability of the ground.
I think it goes slightly to that, but I think Sir James's point, was that Article 9.3 should be understood as capturing statutory provisions which expressly require the decision maker to take environmental considerations into account, but not capturing statutory provisions which say take relevant considerations into account.
Well, like Section 28.
Yes, but I think he's running it not on an arguability. Well, he's saying even if I'm right, that it's not.
Yes, but the question that I put to you was, you accept that that's something we should consider in an appeal against the costs order which has been made.
So one should consider the appeal against the costs order on the basis that my claim is as it is, that Section 28 required the decision maker to take Article 4.1f into account. The fact that it didn't say on its face, this includes Article 4.1f, I say is irrelevant. I think it's that latter point that Sir James is raising. So I'm sure he can deal with it in reply if that is his point. He also, and this is the last point I think I need to make in relation to ground 3, he focuses on the entirety of the Taxation Act, or at least on Part 1, or at least on Sections 9 and 11. And I say that that's wrong. I say we look at the provision. In this case, it is a written provision. It's Section 28, which I say has been contravened. And there's no basis for camouflaging the nature of that provision by reference to the broader regime. This goes back to my Lord Justice Holgate's point in relation to funding and then a statutory obligation to take environmental considerations into account. You breach that provision, you've breached a provision of national law relating to the environment. I think that's pretty straightforward in my submission. One of the few things it is, perhaps, in this case. The consequence, of course, if he were to be right, would be that Aarhus would only apply to bespoke and narrow specific environmental pieces of legislation, which is entirely contrary to everything we've been looking at. If I move now to grounds 1 and 2, I'm just been on my feet for some time now. There's a relationship between grounds 3 and grounds 1 and 2 in any event, because of course ground 3, if I'm right, would provide bespoke, a particular legal requirement for the defendants to consider climate change considerations. And it's in that context that they committed the public law errors that we focus on in grounds 1 and 2. So if I'm right on ground 3, it changes the quality of grounds 1 and 2 in that way. And of course, you already have my submission that if I'm right that ground 3 is an Aarhus Convention claim, the whole claim is protected anyway. As to grounds 1 and 2, you'll have seen essentially their public law challenges, rationality, tame side, ministerial briefing, and so on. Leaving to one side the ground 3 legal mechanism for the decision maker to be conducting that exercise of considering the environment, they had a policy that they would consider environmental impact. So this is in supplemental bundle, tab 6.
So grounds one, sorry, just to orientate myself, grounds 1 and 2 were extensively amended.
They were following some duty of candour disclosure from the other side before the commission hearing.
Bearing a date the day before the hearing.
Yes, absolutely. We applied at the hearing. So what happened was it was going to be a rolled up hearing by the claimants had a very complicated procedural history. An order was made that it be rolled up. We both objected to that, us because we needed Aarhus protection. The other side indicated that they wanted to resist permission and then did the necessary internal activities to make public the information that we needed to know in order for us to have a fair fight about whether permission should be granted or not. That was entirely proper. They were right to do so.
Right.
That gave rise to further unlawfulness.
So the judge was deciding whether this was an Aarhus Convention claim on the basis of a claim that had been added the day before. I mean, I appreciate ground 3.
It had been made the day before. Drafts had been in circulation for some time over the previous weeks.
Yes, but presumably the judge saw them when they were finalised.
She did. And she had submission. She had a day on commission, and then we went away and we came back 2 days later and argued Aarhus. So in fact, it was nearly 2 days of argument, which is probably almost as long as the claim will be itself, I think.
Okay, yeah. Sorry, so I was looking at that, so I missed your reference to the
I gave the wrong reference,
bundle.
so that was very happy for me. Supplementary bundle, tab 7.
7.
7, yeah, I gave the wrong reference, sorry.
Page 90.
So yes, this is page 90. We're in a document. The full document is called UK-Australia Free Trade Agreement, the UK Strategic Approach. Page 34, so that's over the page, sorry, page 91 in the bundle reference. So the top of the page relates to environmental impacts, and then it may be sensible for your lordships to read the whole page, but you'll see under next steps, it says a full impact assessment will be published prior to implementation. So the environmental stuff, then next steps. And then when your lordships have read that, over on page 93, this is significantly later on in the document, which is a long document, under next steps, committed to a transparent and evidence-based approach to trade policy. Following the conclusion of negotiations, full impact assessment will be published prior to implementation. And then full impact assessment will include then the second greater than symbol, further analysis of the sectoral, distributional, social and environmental impacts of the agreements. So essentially there was an impact assessment before the FTA, and then there were these various statements that there would be a full revised impact assessment once it had been negotiated and prior to implementation.
So you can just give the last reference?
Yes, on page 93.
93, sorry.
Yes, it's the full impact assessment will include, and in fact there never was another impact assessment.
Well, it's not entirely easy to follow this document because we've only got...
It's so excerpted, isn't it? I'm sorry.
We've only got a couple of pages, but it's advertised on page 2 of the bundle as the UK Strategic Approach, starting at page 26. And then that's in June 2020, and then there is an impact assessment in December 2021 as item A.
So
there was an impact assessment after this.
So the key words are prior to implementation.
Of what?
Of the FTA.
And the
So
when was the FTA again?
16th. Well, it came into force on 16th of December, the same date as the impact.
Yes, right.
Yeah,
Thank you.
Hence your prior to.
exactly.
It might be helpful, and I hesitate to say this, just to have 1 or 2 pages from the beginning of this document to actually help explain what on earth it is.
Of course. Well, we can do that. We'll get that.
If that could be agreed.
Of course, I'm sure it can be.
As few pages as possible to put it into its context.
I'm sure that's right.
I'm sure that's what my lord has in mind.
Very much so.
Yeah.
So it's right that the policy wasn't required by statute, and it's a policy that the government chose to adopt, but adopt it they did. And so we say that if we're wrong on ground 3, if ground 3 weren't to exist, and if I were to be wrong in my submission to your lordships, that you have to consider ground 3 as part of my claim, imagine that's all wrong for some reason, and when we're thinking only about policy, having adopted it, they need to adhere to it in the normal way, which means to take account of it, and if there's a good reason, they can depart from it, and if there's not, there's not. And if we're using a test, which I don't positively contend for because I'm team full onion, if we're positing a test, which for example is the legal framework ex ante discernible? So would one know in advance of making the decision what the decision maker needs to take into account, what they need to adhere to? Then this would form part of that rules-based legal framework which the decision maker needs to act in accordance with. And the errors, the irrationality...
Sorry, just to make sure I've caught up with you. The policy says there will be an impact assessment.
There'll be a further impact assessment with full account being taken of the environment.
So this way of putting the case would underpin also ground 3
well,
and your Australia-England point.
Yes. Yes,
But
there's a relationship.
A lot of grounds 1 and 2 are very precise grounds about the way the impact assessment was carried out. That doesn't relate to the policy as such.
It doesn't relate to the policy.
Those are just straightforward irrationality grounds.
They are, absolutely. So I think the complexity...
I mean, they're logic grounds, for example, based on Lady Justice, she then was Mrs. Justice Carr's judgment in the Lord Chancellor case.
Yeah, absolutely.
Yeah, okay.
So difficulty in this appeal, I suppose, is the main way, or I think the main way in which the argument against me is being advanced, is something like a quality of law argument. To say that one looks at the statutory regime and whether that's environmental, and that then cloaks the nature of the legal error with the right characterisation of that regime. So the reason that we're being pulled into discussing things like, what if it weren't the statute that was environmental, but what if it was the applicable policy that was environmental, and the public law error sat on top of that policy, would that be enough? Or what if the public law error sits on top of a mandatory consideration? Would that be enough? So I know it is a really confusing point, and I probably made a terrible hash of explaining it, but it's quite close to the point that my Lord Justice Holgate put to me earlier on, when he said, well, look, administrative law doesn't exist at large. It's not there in a vacuum. It's not like a common law cause of action. That's what your Lordship said to me. And instead, those errors only take place in the context of certain decision-making.
How?
Sorry?
They only take place in the context of power.
Of course, of course. And so my learned friend says, well, it's all about the statute then. But I say that's not right. It builds out from the statute to include not only policies that are mandated by the statute, we know it goes that far, that's then, but also policies which the decision maker chose to adopt. I also say that it goes as far as to include mandatory considerations. So the mandatory considerations are Fewing's category 1. So that's what we were discussing earlier in relation to the proper construction of the statutory regime and the considerations the decision maker has to take into account.
But which are what in this case?
In this case, I think we're Fewing's category 3, which is material ones. So at this point, I'm explaining or seeking to explain to your lordships how it might work in general for other claims. But there are various statutory regimes where one can look at the statute and discern that there's a fewings category 1 consideration.
Yes. I mean, I think I can say that although we will be keen to ensure that our judgments are as helpful as possible, we do have a general principle here of trying not to decide more than we need to. So in this particular case, I understand how you put ground 3, and why you deal with that first, and how you put grounds 1 and 2 under, and how you fit that under Article 9.3. But those are all on the basis of either the two provisions you've shown us or the policy you've shown us.
That's right, my lord.
So as far as considerations, what does that, if anything, add?
So if I were to be wrong on section 28, and if I were to be wrong on the policy, and your lordships were to find, or the learned judge in due course were to find the policy didn't work in the way I say, then we'd be in a world in which the decision maker had chosen to look at the climate change consideration and have all those public law errors in the decision that he or she.
Okay, so that's not mandatory considerations, that's voluntary considerations, but nevertheless they had regard to them.
Absolutely, apart from, and I'm sorry this is so complicated, ground 1C is a ministerial briefing point.
That's the predetermination point.
It's actually predetermination is ground 1D. Ministerial briefing.
Oh, there's not enough information given to...
Exactly, or it's so wrongly briefed.
National
in fact,
health
they didn't.
Stores.
Exactly, national health stores, it's that point. So that takes us into fewings category 3 materiality. I'm sorry it's so complicated.
And that was 1C, one of the ones added by way of amendment?
It was. It was. So in that sense, by way of fallback...
You will demand a lot from our first instance judges, I have to say.
I'm sorry about that.
I mean, you expect them to be quick, polite and right.
Oh.
And 99%...
unreasonable.
99% of the time they meet that, but you really do demand an awful lot of them. Here we are, here's an amendment, that means this, there's the law, and I think, what's the answer?
Well, my lord, we did what
That's
we
not to discourage you in applying to become a judge, because it's the best job in the world, but I mean, it is fair to say that in particular in these cases, I often sit here and think, I'm glad I got out when I did.
I can imagine that.
Anyway, so they have chosen, you say, to consider the environmental impact, and therefore the usual public law obligations apply.
Absolutely, but in my case, these are all fallback positions because
I understand that.
Ground 3 is ground 3, and I say it's pretty straightforward, despite the hours I've been on my feet for.
There's just one bit certainly one bit I've not understood.
Sure.
The policy. I understand it's the next line after section 28 and Article 4.1f.
Yeah.
But the policy would normally be relevant if you were alleging a breach of policy. But this policy is expressed in very high-level terms. There will be an assessment. It's not a policy which says how it's going to be carried out, for example. Is that correct?
That's right. That's right. So I
can see how it underpins ground 3, but I'm just struggling to see how it would...
Well, it underpins... Sorry to cut across you, go on. It underpins grounds 1 and 2 because my learned friend, as I understand his submission, says that a mere public law error advanced in the ether doesn't tell you anything or doesn't tell you enough about connection with the environment. And instead you have to look at the reason, the legal mechanism...
Well, what you're doing, in other words, is to use the policy à la veine, if you like, to bring this within the scope of Article 9.3. Having done that, you can then pursue all your public law errors.
That's it. That's exactly it. You put it far, far better than I think.
That's what I was really trying to get at. In that sense, it's analytically no different from relying on Article 28, Section 28 plus Article 4.1f.
Exactly.
It just gets you over the Article 9.3 hurdle so that you can then bring in your public law errors under grounds 1 and 2.
Exactly
as well
so.
as 3.
Exactly so. And that's one of the reasons why it doesn't feature large in either of our pleadings. It's only really in the Aarhus connection that it matters so much. But there we are. It's that kind of legal mechanism, my lord. So we have, were you obliged to do it by way of statute? If yes, then you can piggyback on your public law errors. Were you obliged to do it by way of policy? If yes, piggyback on your public law.
I'm sorry to be slow.
No, you're not being at all. I've been very inarticulate. And then mandatory considerations were there. And then I also say optional considerations. And the reason I say that is the reason we've discussed now a couple of times, that having decided to take those considerations into account and having ex hypothesi committed a public law error in that regard, if one is not in Article 9.3, then the public cannot bring a claim to challenge it, or at least the Convention does not require that the public should be able to. So that's where I go as far as optional considerations. Mm-hmm. I fear that I've made everything as clear as mud in the course of my submissions. I'm sorry about that.
No, I don't. I mean, it's, this is an important case, and it's not straightforward. And we're conscious that judges in the administrative court deal with Aarhus Convention applications under the Aarhus Convention all the time, and there isn't very much by way of authority from this court on that. So we're very conscious of that, and that's why we suspected we may be taking most of the day, for which we apologise to the extent that we've added to the time. Does that conclude your submissions?
I think so, yes.
Well, let me just check. No, my lords have asked their questions as we've gone along.
Thank you.
As you may have noticed. Yes, thank you very much. Yes, Sir James.
My lords, I wanted to start, if I may, with what is on its face, as we know, a relatively simply stated test, giving rise to all sorts of complications, as you've heard during the course of the day. The test is whether the challenge is one which asserts a contravention of the provisions of the country's national law relating to the environment. That's the critical phrase that you've got to consider. Just before turning to that directly, can I make 2 points, as it were, briefly by way of introductory outset. The first of them is that my Lord Justice Holgate drew attention to the fact that, I think it was in Article 2, there was a reference to the air as well as the land, if I can put it that way.
The atmosphere.
The atmosphere. And we entirely accept that within that concept of environmental information sits the air emissions and all of that. One gets to the same point, if I may say so, from Article 6.6c, which refers in terms to emissions, to emissions rather than admissions, emissions. The second point, however, is rather more of a point of disagreement with my Lord Justice Holgate. You referred to Annex 1 to the Aarhus Convention and to the fact that it had lots of references to animals in it. I simplify the point. It does, but you'll see when you go back to it, I hope, that all of those references are in fact, in essence, to buildings, to projects, to the sort of things that one would expect. It's very like planning, as it were. It's to the creation of a structure or a building in which there is farming of an intense kind.
Unfortunately, intensive livestock rearing is normally inside a building.
Well, exactly so, but it's the building that is referred to within Annex 1.
Well, it will cover the use.
It covers the use as well, but it's like the planning thing. So it isn't just, is the short negative point, it isn't just lots of animals, so it's beef, 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 if I can put it that way. Animals must be covered because they're referred to in Article Annex 1. It's not quite as simple as that, if I may respectfully say so.
I'm sorry if I gave that impression.
No. I just wanted to clear that up as to what the focus of Annex 1 is. There is then a question about whether there is truly, as my learned friend asserts, a distinction drawn by the Convention between the idea that was originally conceived of in, I think it was Annex 5, and I took you back through the Travo last time, the provisions of its national environmental law, is there a difference or a distinction between that as an idea, as a phrase, provisions of its national environmental law, remember that was Annex 5.1, as compared to the final version, which is provisions of national law relating to the environment, which is the form in which Article 9.3 ultimately came about. And the short point I wanted to make in relation to that, without trying your patience too far in relation to the Travo, is that there is no indication at all that anyone thought that that change of wording was anything other than a tidying up of the wording. So if and to the extent that my learned friend suggests that that change of wording indicated a deliberate intention to broaden the proposal from that was agreed during the 5th session, that we respectfully submit is plumb wrong. If that had been the intention, one is bound to have seen something of a discussion to that effect, indicating that that was the intention. That's what needed to be done as a matter of policy before the drafting reflected that. That would have been mentioned in the Travo, and there's no mention of that at all. And that's common ground, that there isn't any indication in the Travo of a change of policy of that kind to broaden it beyond the provisions of its national environmental law. Indeed, in the 8th session, when the final thing was done, that's in the bundle at 556 to 557, the authorities bundle, but there's a lengthy debate about Article 9, but nothing at all to suggest any form of change of policy of that kind. All that the new version of Article 9 did was to substitute the slightly changed version with no indication that was intended to be a change of policy. And that is borne out by the fact that the French version that you see remained entirely the same, absolutely identical, as between the 5th version and the version that ultimately became Article 9.3. So my learned friend's reliance on the fact that there are two linguistic versions which have the word related to in it goes nowhere once one acknowledges, as is entirely evident from the Travo, that that change of wording in the English version, one knows not whether it was a change of wording in the Russian version, because we don't have the Russian versions of the various discussions, but it matters not. All that change of wording was doing was simply a tidying up exercise. It is not evidencing a change of policy designed to broaden the concept that governs Article 9.3 beyond, and this is the core point, the direct focus on the provisions of a country's national environmental law. And we submit, therefore, that the Travo do provide a positive support to that idea that the focus is on the nature and quality of the law, that is, the national law in question. My learned friend then sought to rely in order to give, of course, that doesn't remove the need for you to construe.
So the upshot of that submission is that 9.3 could be read as if it was indeed referring to
national law,
a provision of national environmental law.
Exactly.
They could have drafted it that way and it would have the same meaning.
They could have drafted it that way, it would have had the same meaning, and indeed in the French version that's exactly what happened. It started in one way and it remained the same. Quite why the change was done in the English and perhaps the Russian versions is a bit opaque, but the one thing one can say with some clarity is it was not designed, evidently, otherwise one would see reflection of it in the Travo, as some form of important broadening change of policy. Next, my learned friend, of course, as I say, that doesn't remove the need for you to construe what ultimately related to means, because that's the wording you've got to grapple with, but it does give you some indication, perhaps.
Well, that means we end up with an interpretation of in relation to as having to do with.
Having to do with, exactly. And so we submit that as an important point. My learned friend says against that, well, look at what the committee do, particularly in the Austrian case. You'll remember she took you to that, I think it was paragraph 52 perhaps of, or 9 was it, of Austria, page 102, where the committee itself introduced what it said related to meant with the IE, which prompted my Lord Justice Coulson to say, well, that's just a description of related to. But one needs to be a little careful of that. I referred rather too quickly, perhaps, and rather too flippantly to to the judgment of the Supreme Court in AB. And I do want to go back to that very briefly, particularly because, as my lord rightly pointed out, there was a reference in one of the cases to Coulson, which was a Supreme Court case. Do you remember there was a quotation from Lord Carnworth, JSC, which gives us on a bit of a clue that it was a Supreme Court case. So there we are. But AB comes after Coulson, and AB is the latest word on how one approaches.
And that's tab.
These sorts of bodies. That is in, I'm afraid it's in the other bundle. It's in the WWF bundle, tab 6. And the page I want for present purposes is page 347. You have, and I'm not going to go back on my points relating to the Aarhus Convention itself and the setup of this committee, all the consensual, not a judicial body and all of that stuff in Article 15. I'm not going to go back to that, but it provides the backdrop to these paragraphs. And I wanted to just invite you to read, again, it's about a page, but could I invite you to read what is evidently a considered section from Lord Reid. This isn't just a throwaway section, because there had been previous cases, including in the Supreme Court, when, it might be said, under different management, there had been a series of cases in which considerable reliance was placed on these sorts of international committees and what they had to say in various contexts. So this is a considered view of the Supreme Court about the right approach in principle post-Coulson. Para 64, bottom of page 347, if you would, to the end of para 67. So you'll see immediately the chimes to the present case. I mean, no doubt the way of setting up the different committees are somewhat differently phrased, but not very. And if and to the extent that they are differently phrased in relation to the committees being considered by the Supreme Court here, the points that they make about the need for caution when considering opinions expressed by these sorts of committees are a fortiori in our context, given the content of Article 15 of Aarhus. So we say be very careful with that for those reasons. But ultimately, the debate between my learned friend and I in relation to what contravened provisions of its national law relating to the environment means comes down to a distinction, ultimately, with us in the left-hand corner, as it were, saying the critical focus is on the statutory framework and its nature and character, indicated inter alia and in particular by its objective or purpose. And my learned friend effectively saying, whenever you can build out a public law challenge under domestic law, as long only as the nature of that challenge to the decision has something to do with the environment you're in. And we respectfully submit that it was revealing that at one point in her submissions, she made the positive submission that the question was whether the thing in question, as it were, the challenge in question, the decision in question, related to environmental law. And that's entirely the wrong way round, I respectfully submit. And what it does by framing the point in that way is to take away from the clear interpretation of what 9.3 actually says, which is about the contravention of the provisions of its national law relating to the environment. So it's got to be the national law that relates to the environment. It's the nature of the law that is the focus, not just the impact of it, however much my learned friend seeks to blur that and bring it all back to impact. It's got to be sufficiently closely related to the environment as a law. And my learned friend is perhaps right to say, in relation to Deutsche, just to divert to that for a bit, remember she went back to Deutsche and said it was sufficient but not necessary for the purpose of the reasoning. And to some extent she's right about that, because the ultimate issue was about the source of power and all the rest of it. But I took you to the paragraph in which the European Court, no doubt intentionally, drew that link between the national law and its objective.
Was that paragraph 52?
It was, the national law and its objective, and the thing falling within Article 9.3 of Aarhus. Because the objective is this, therefore it falls within Article 9.3. And I respectfully submit that that is the correct approach, because it focuses on the connection between the national law, not just the decision or what grounds under national law are asserted by way of error, but on the actual national law in question. It cannot be, that we respectfully submit, any impact on the environment. That's far too broad. It isn't a test which says, look at the decision. Does the decision have a bit of an impact on, or a significant impact on the environment? If they wanted to set up the test that way, they could easily have done so. They haven't done it. They've focused on national law for good reason. And it is of some interest, or it was of some interest, to listen to the debate that occurred when the court was probing the breadth of my learned friend's submissions. Because ultimately, the case that is truly being made is remarkably similar, to put it at its lowest, to the extreme case that WWF is making. Her case is that if only the environment is relevant to a consideration that becomes material in public law terms to the decision, whether because it's mandatory under a statute or it's optional, a la Mozambique, as long only as there is some connection with the environment of that material consideration, that's the connection she drives at, is the material connection, is the material consideration connected to the environment. That's her key controlling factor, but that isn't a controlling factor at all. The material consideration dragged in mandatorily or optionally in that way doesn't even have to be, on her case, to an international agreement relating to the environment. It can be just a material consideration that you didn't take into account something to do with the environment, some impact on the environment. That's why she had to swerve a bit when asked the question about impact. Because ultimately, if that is the position which is taken, which we respectfully submit it appeared to be, then the truth of it is that what is really being posited is a test where you look to see whether the decision relates to the environment. And that is not the test under 9.3. Indeed, she goes further than that in two respects. One of them is, she says, you don't have to go anywhere near a statute in domestic law You could have a decision under the prerogative, she says, which might have an impact on the environment, and that would be within 9.3. But that's an extraordinary submission. Why wouldn't committing troops to Ukraine, for the sake of argument, fall within that test? And she denied, in answer to my Lord Justice Holgate's question, whether it was a connection to the statutory framework that had to be made. And she said, no, it doesn't. You don't have to make any connection with the statutory framework. And we respectfully submit that that drives a coach and horses through the very careful wording of 9.3. My Lord Justice Coulson has made the point on a number of occasions, and of course it is a point that deserves the most serious consideration, that what has to be done by the poor old first instance judges is to make decisions at a relatively early stage on the basis of potentially relatively limited material, and one doesn't want to overcomplicate it. And everyone can no doubt surround that as a basic proposition. But it does come with a but, I'm afraid. The but is that where that leads my learned friend is to say whole onion, as she rather charmingly put it, by which she means everything, every ground by which you can challenge a decision under public law, so long only as that decision has some impact on the environment. And simplicity is not a coherent driver for over-inclusion in principle, still less a driver for the correct interpretation of the words in the International Convention and Article 9.3. But the second point is a more intensely practical one. However much it is appropriate for the courts below to have some relatively easy principled assistance on how they go about deciding these questions, these are questions which bear, and bear strongly, on the distribution of resources within a nation state. Because it is, in nature, a subsidy for a certain type of claimant, as the court well appreciates. And it does make a big difference. It makes a big difference because the costs that the public purse would then have to bear, win or lose, can be very, very significant. And again, I hate to keep going back to Mozambique, but their Mozambique case is a good example. We spent however long it was, 4 days with very large teams, vast quantities of documents, having an argument about these points of whether international law had come in, if so, how had it come in, whether was there a rational approach, was Mrs. Justice Carr's reference to logic the right way of looking at it, if it was there that sort of error? And of course you build out the case, you just challenge every part of the assessment and say it falls within Mrs. Justice Carr's logic. It's not very difficult to do, it's not very difficult to build a case of that kind. And what that means is that in the context of Mozambique, that entire piece of litigation culminating in 4 days in court and detailed arguments and up to the Court of Appeal and everything else, that's £5,000 and the taxpayer bears the rest, even though the result was as it was. It is right also to acknowledge, whilst on this theme, that one needs to be a little careful about assuming, and it may be that I should have gone here earlier in my submissions in answer to the question my Lord Justice Stuart-Smith asked me, one needs to be a little careful about permission, therefore it hasn't been brought or whatever. The position under the... But permission, therefore... Therefore, if permission is refused, you don't get it, as it were. The position is, as you know, that under the rules as they currently stand, and the Mr. Justice Eyre case is an example of this, you can get the Aarhus protection even if permission is refused on all grounds. So if, for example, you go to tab 17, if you would, very, very briefly, sorry, just to make the point good, you will see that in the Welsh Ministers and Velindre University NHS Trust case, starting on page 349, you will see that there were lots of challenges, 2 or 3 challenges brought, and ultimately they were all turned down. They were all refused permission. But nevertheless, the costs payable by the claimant were limited to the £5,000 limit because the judge concluded it was an Aarhus claim. So that even if permission is refused, on the current state of the law, as I understand it, and the rules, the Aarhus protection applies. There was some consideration about whether or not you could get to a no order for cost thing under the current state of the rules, and I think my learned friend took you in that respect to the civil procedure rules behind tab 5.
Page 55.
Page 55. But you need to be very careful about that, I think, because if you look at 4628 sub 3 sub A, you'll see that that is a reference to the power in the court to make said order in the context of proceedings to determine whether the claim is an Aarhus Convention claim. So that's about the costs of the argument about Aarhus. It isn't to do with broader substantive merits of the good, bad or indifferent of the claim itself.
Well, I notice in the Lewis case,
Yes.
hearing date 17 November 2021, followed by written submissions on the issue of cost capping.
Yes.
So there it was,
done by way of written submission.
but it was done in that sense the other way round.
Yes.
To how I think you both think
Normally it would be done
normally,
first.
or you would say conveniently for both parties.
Yeah.
Because you would say if they were being done in a sequence, Aarhus should come first so people would know what the cost position was.
That would be the logical way of doing
Yeah.
it. But no doubt for pragmatic reasons, in lots of cases, it all gets blurred up together.
Of course,
You've got a few
understand
examples.
it. You can't, in an ideal world,
Yeah.
you can't, in a practical world, you can't do it, but in an ideal world, that's how you do it. Yeah, okay. I'll have that.
So one just needs to be a little careful about thinking, well, there are lots of marvellous potential duckouts for controlling this in other ways, and you might be able to escape from the strictures of it. And that I respectfully submit is a very different, or potentially a very difficult thing. So all of those submissions go to, as it were, entirely understand and accept the drive for simplicity, but to recognise that the issue of how this works and whether or not people should be granted, in effect, the £5,000 limit, however complicated, long and convoluted the litigation path may afterwards be, with the consequent impact on the taxpayer, it's a pretty important and big issue across the board because of the transfer of risk onto the taxpayer, in effect, win or lose, whether the government wins or loses, whether the public authorities win or lose. And of course, that is to some extent exacerbated by the fact that you, at least on one view of it, there is some risk that a person simply mounts claims asserting these sorts of things, asserting an impact on the environment. Now, no doubt the cost could be brought to a shuddering halt by the refusal of permission, so there is that discipline within it, but it's not a complete answer. And my more significant answer is that permission is a relatively low hurdle. Some of these issues about the introduction of international law and all the rest of it are complicated, and it's very easy to mount a claim that in effect challenges a process of analysis or assessment on its merits, because it's the easiest thing in the world to say at the permission stage, well, there is the Law Society Lord Chancellor case that my Lord Justice Holgate referred to. I think it was Lord Justice Leggett and Mrs. Justice Carr, as she then was. There's a logical flaw. Well, you can argue uphill and down dale about whether there's a logical flaw or not. So these claims are not very difficult to get through the hurdle, as indeed the reported case law tends to indicate.
Mr. James, forgive me. These last few minutes of submissions don't really take our task any further, do we? I mean, we understand that it's a significant thing when cost capping is imposed, but it doesn't help us decide how to interpret Section 28 or Article 9.3, does it?
My Lord, the only way in which it does so, I respectfully submit, and it's a significant way, is to go back to my purpose of submission. You remember I referred you to reasonable cost being the default rule recognised in Aarhus, and states will be well aware that the basic purpose of 9.3 when read with 9.4, partly my Lord or Justice Holgate's point that says focus on remedy in 9.3, but when you read them together and it's about costs, the states will have been well aware that the effect of this would be a departure from that acknowledged rule that parties can require, or the states can require parties to pay reasonable costs and assume the reasonable cost burden. This is an exception to that. That's the very purpose of it. And so one needs to be a little wary about throwing open the door, as it were, to all of these matters. Well, that takes me perhaps to the last point, which is just by way of reply, because you're well aware of what the issues are now. But you know my submission, which is you've got to focus on the national law, you've got to focus on the nature of the national law, and a mere introduction by way of either mandatory or optional relevance in a particular decision-making context of something to do with the environment is not enough. Because although true it is that in that coach driven by those horses comes something marked environment, but that is not the focus of 9.3, which focuses, that we submit, on the statutory framework and the national law itself and its nature and quality. And we do note that there can be relatively difficult questions about precisely how you might go about having regard to particular things, even if they do become relevant to be taken into account. One shouldn't lose sight of the fact that there is a big distinction in public law terms between simply taking something into account, giving it such weight as you see fit, and having to produce an outcome which is compliant with, say, an environmental standard. And indeed, if we've understood it correctly, the case that my Lord Justice Holgate was taking me to task about, at least hypothetically, before the short adjournment, is actually not very far away from the facts of a real case, which my Lord decided, called Transport Action Network, about the road infrastructure and things being taken into account. And without wanting to go back over all of that, what it does indicate, that case, it's 2022 PTSR 31 or 2021 EWHC 2095 admin. But what that case does illustrate, particularly the passage at 121 to 126, read with the relevant statutory provision in 29 and 30, is that even if you have a statutory provision that says take into account environmental matters, as it did in terms, if I've understood the decision correctly, you still have a question to ask about what the nature of that taking into account obligation is, and whether it truly bears on the thing that is being challenged. So the conclusion that was reached, again, if I've understood it, was that the statutory obligation to have regard to environmental effects of a certain kind did not, in that particular context, lead to environmental decision-making of any kind, as it was put there. That's not quite the same as the Aarhus issue, but it gives you an illustration that you always need to look at the context and the purpose and the statutory framework. And the test is whether or not that statutory framework has that environmental objective. But you need to look at the statutory scheme and you need to analyse the duty, including taking into account that sort of very high-level duty to have regard to material things or things you choose to have regard to. But if the position truly is, as my learned friend asserts, that any form of public law error or asserted arguable or even not arguable public law error is enough, then the nature of the control that the Aarhus Convention in 9.3 deliberately set out, the tie, the relation between the environment and the thing to which it has to be related to fall within it, namely the national law has to relate to the environment, is in effect completely broken. It just becomes open house with all the purposive difficulties that that creates. So, my lords, those are my submissions in reply.
Yes, thank you very much. Thank you very much, Sir James. Excellent. Right, well, thank you, both of you very much, and to all those who sit behind you. This is an important case, and it's not straightforward. It's also been extremely interesting because it's 4:10, and at least for me, the time has flown. You will be unsurprised to learn, be reserving our judgments. And as you both know very well, you will get a copy of the draft judgment when they're done, which is an opportunity to correct our spelling, our typos, and anything of that nature, but it's not an opportunity to re-argue the case. The draft will be sent out and will be confidential in the normal way. You're both very aware, I know, of the rules that relate to that. Those that are on the list, which my clerk, I think, has the lawyers to whom it is to be sent, it will be sent to those lawyers and nobody else. Of course, both sides have the opportunity to discuss the draft with a key decision maker or two within their organisations, but not anybody else until the judgment are finalised. Once you've got the draft, we hope you'll be able to agree the order, which will be consequential. If you can't agree the order, the best thing to do is to provide a draft order with the competing texts for the particular bits you don't agree in square brackets, and very short written submissions on those points on which you disagree, and we will deal with those points and the order on paper, and the judgments will be handed down in the normal way now, electronically, so there will be no need for any further attendance. There isn't anything else I need to add, so just again, thank you all very much.
All right.